How's it going? Good. Good? You doing okay? Is that your lawyer who made the scene? Wilson. Present. Haley.
Present.
And Porat, present.
Could I get an authorization to excuse Mr. Ford? Need a motion and authorization to excuse Mr. Ford.
I move to excuse Commissioner Ford.
I second.
Been properly moved and second to excuse Mr. Ford. Roll call.
Wilson,
Yes.
Maley,
Yes.
Pratt.
Yes.
Next item, are there any amendments to the agenda that we don't have? Are there any amendments to the agenda? Okay, hearing none, can I get a motion to receive approval of the agenda?
Motion to approve.
I will second the motion to approve the agenda.
It's been moved and properly seconded that the agenda be approved as printed. Roll call.
Maley,
Yes.
Rath,
Yes.
Wilson.
Yes. The agenda items, we'll start from the agenda items with number 1, non-overlay provisioning centers appeal hearing. It's on.
You're fine. It's on. I can see the light.
Uh, Start with agenda item number 1, discussion on Greenstone, Michigan LLC, known as Nugget Michigan Appeal. Nuggets Michigan Appeal. Any discussion on item 1?
Yes, I can begin on that. Greenstone, Michigan was the non-overlay district, number 139 applicant, proposed location at 284 South Telegraph Road. Tonight they are appealing 3 things, primarily with a subsection on the third. The first thing was noted in the appeal is that the evaluation process was fundamentally flawed by conflict of interest amongst personnel who've reviewed the application. The second appeal was that the inclusion of the scoring criteria on the interim city clerk's non-city website created a 2-tiered application process that prejudiced Greenstone and other applicants. And the third was appealing specific scores of number 1, community development, a score of 6 of 10, 2, facility planning, score of 4 of 8, 3, facility sanitation, a score of 1 of 2, 4, patient education, staff training and education subsection, score 1 of 2.5, 5, land use, the neighborhood land use, a score of 5 of 10, and 6, financial resources, a score of 5 or 10. Regarding the first, this commissioner does not, I cannot adequately address the appellant's argument regarding the review process being fundamentally flawed by conflict of interests. I just have no knowledge of that or was not involved in the process at the time. As for number 2, with the appellant's argument that the scoring criteria could not be located, it was not readily accessible to them, and was only made known to them after the application deadline had passed, and therefore should not be used as a basis for scoring applications, and I'm paraphrasing here. I believe that logic is flawed, in my opinion, because A, the medical marijuana facility permit application instructions list the address and phone number for the Pontiac City's clerk's office as a footer on every page of it. B, further, on page 2 of 21 of the application instructions, the references section lists, among other things, an ordinance number 2363 with recent amendments to the City of Pontiac zoning ordinance regarding medical marijuana facilities is available on the city clerk's webpage, and it gives the address as http://www.pontiaccityclerk.com. C, further, page 6 of the application instructions lists right under the major category scoring rubric as the last paragraph on the page. For a detailed explanation of the scoring criteria, please see the City of Pontiac Medical Marijuana Provisioning Center's scoring criteria. Now, from these points, it's clear to this commissioner that 1, the city clerk can easily be reached by telephone. 2, A separate website for the city clerk exists and contains pertinent information to this application process. And 3, a detailed scoring guide exists and should be located and followed by each applicant. Now, from the information clearly provided and using basic reasoning, this commissioner would have simply picked up the telephone and dialed 248-758-3200 and asked the city clerk's personnel, "Where may I find this scoring criteria guide that is mentioned in the application instructions and contains detailed scoring criteria for the application process?" With that reasoning, I do not find that the appellant's application was graded arbitrarily or capriciously in the overwhelming body of instances, and I disagree that the scoring criteria should not be used as part of the review process. I will let my fellow commissioners speak to these specific scorings.
I have on community development. The applicant was found to have mislabeled items, had other items filed in the wrong section. Cites information not provided by the appellant. We don't find any information related to the amount of time or financial commitment to each program, the length of each program, where community outreach meetings will occur, how often they'll be held, efforts to connect with community leaders, and the description of the involvement of key stakeholders. However, it plainly states in the scoring criteria guide in section 8C, I'm sorry, I got the wrong, HC 15, that these criteria about numeration, how many, the duration of, let me get the exact wording here. Blah, blah, blah. Okay, on page 5 of the scoring criteria guide, okay, under 8C 15, line 37 says duration of pledged community benefits, a description of the amount of time or financial commitment, a description of the length, days, weeks, months of each commitment, and community cumulative duration. Right, they were awarded 6 out of 10 on that, and I do not believe that was arbitrary and capricious, and I agree with that score of 6 out of 10 for that section alone there. Mr. Wilson?
Yes, before getting into the discussion, I wanted to read one paragraph from what Greenstone submitted its appeal on. Greenstone submitted its appeal of this initial scoring determination on September 3rd, 2021, and the hearing on the appeal occurred before Greywall Law P. LLC. The appointed medical marijuana hearing for the city was on October the 28th. At the hearing, Greenstone argued that the city erred with regards to several of its scores based upon information that was submitted in its application, and it also that the overall scoring process was flawed. So they have 2 sets of what they argued. Sorry. There were 2 sets of points that they argued. They argued, number one, that the city clerk erred in the process of how they scored them. And secondly, they argued that the overall scoring process was flawed in multiple respects, including through the presence of several conflicts of interest among applicants reviewed. So Greenstone has several different arguments. In retrospect of what my colleagues have already said, I do notice that on August the 20th, Greenstone did receive a score of 105.5 out of 130 points, and they had submitted an application for 2 84 South Telegraph Road. In my observations and looking through all of the application process and the material that was submitted in support of what my colleagues have already said, I noticed that under community development, the instructions was clearly spelled out for community development, because that's one section of the process that they argued. But on page 12 of 21, it also clearly spelled out what the process was and what material needed to be submitted when you look at the scoring guideline. I also noticed that under facility planning, there and again, on pages 14 of 21 of the application process, it clearly spelled out the material and things that was needed for the process. Then again, if I also look at the website and the application instructions that was there, if I look at pages 13 of 21, and if I look at the process itself and the instructions were clearly spelled out. On the facility sanitations, there and again, they argued that no contract was required with respect to this item as above. They were arguing what items were required and what items were not required. But if you look at all three phases of the instructions, if you look at the scoring cube, and if you look at the application process on various pages, it spells out everything that was really needed. Now, one of the things that I do notice is that when the hearing officer did listen to and review the process, they did add an additional 4 points, which is the recommendation that was made to the city clerk. The city clerk did take under advisement the 4 points that was recommended on the neighborhood land use, and it did change the score, and the recommendation coming from the hearing officer was to change the score to 109.5 out of 130 points. So the city clerk did take in consideration the hearing officer's suggestion and change the score. But I must say, as my colleagues have already said, under the instructions that was issued, it was clearly spelled out on various pages as to what the instructions were. With that being said, I would like to move on to the resolution on Greenstone, Michigan LLC, known as Nuggets Michigan Appeal. Read the resolution. Resolution on Greenstone, Michigan LLC, Nuggets Michigan Appeal to the Medical Marijuana Commission. Whereas on 2018, voters approved the City of Pontiac Medical Marijuana Facility Ordinance 2357B. And whereas Ordinance 2357B gives the city clerk the responsibility to score and rank applications for provisioning centers using a 130-point scoring system and awarding permits to the 20 highest scoring applicants. And whereas the City of Pontiac adopted Ordinance 2363, an ordinance to include medical marijuana facilities use in designated overlay districts, and whereas Ordinance 2363, Section 2.546, Medical Marijuana Provisioning Center, Section F, licensing states that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay districts, including Cesar Chavez, Walton Boulevard, and C2 Downtown Overlay District. And whereas Ordinance 2363, no more than 5 provisioning centers shall be established in the C1, C3, and C4 zone properties combined outside of the Michigan Marijuana Overlay District. And whereas the city clerk accepted provisioning center application by overlay districts and the non-overlay for a 21-day period of January the 6th through the 27th, 2020. And whereas the city clerk ranked and scored provisioning centers by district using a 130-point scoring system. And whereas the city clerk informed Greenstone, Michigan, LLC, known as Nuggets, Michigan, that their application for a provisioning center in the non-overlay had received a score of 105.5 of 130 and ranked 23rd of 48 on August the 20th, 2021. Whereas Greenstone, Michigan, LLC, Deb Nugget, Michigan, appealed the score and ranking to the city clerk since its application was denied because it was not ranked in the top 5 for the non-overlay. The city clerk appointed Graywell Law P. LLC to serve as the hearing officer. The hearing officer conducted a hearing on October the 28th, 2021. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation. Based on the hearing officer's recommendation and other appeals in the non-overlay, Greenstone, Michigan, ranked changed from 23rd to 21 and remained not ranked in the top 5. Therefore, Greenstone, Michigan, LLC, Deb Nuggets, Michigan application was denied. And whereas Ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission. And whereas Greenstone, Michigan, Deb Nuggets, Michigan submitted an appeal to the Michigan Marijuana Commission on December the 29th, 2021. And whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Greenstone, Michigan, LLC, known as Nuggets, Michigan, appeal. And whereas the Medical Marijuana Commission reviewed Greenstone, Michigan, LLC, Nuggets, Michigan appeal, and the city attorney's recommendation. Now, therefore, be it resolved, the Medical Marijuana Commission find no basis to overturn the clerk's decision to deny Greenstone, Michigan, LLC, known as Nuggets, Michigan application for a provisioning center in the non-overlay. That's the resolution. The floor is open for a motion to act on this resolution.
Motion to take action.
I second the motion.
It has been moved and properly second that the resolution just read be received. Can I get a roll call?
Prath,
Yes.
Wilson,
Yes.
Maley.
Yes.
The motion to receive and adopt the resolution has been approved. Next item on the agenda is item number 3, discussion on Greenstone Natural Remedies Appeal. Discussion on Greenstone Natural Remedies Appeal. Any discussion?
Okay. I will start again. So Greenstone Natural Remedies, also Silverdome Meds, is the non-overlay 110 applicant at proposed location 200 North Opdyke Road. They are appealing the facility planning section with a score of 4 of 8 and the facility sanitation score with a score of 1 of 2. The appellant argues that the above points were improperly deducted or withheld erroneously during the initial scoring, subsequent review, the first appeal process, and with the issues being that the facility planning, the scale diagram supplied did not meet the application criteria for Section 8C19 that states the applicant must submit a scale diagram illustrating the property for the proposed facility, and that such a scaled diagram must be in the form of a property survey prepared by a licensed professional surveyor. In multiple places throughout the application process, there are mentions for requirements to have all documents labeled with proper reference section, and that failure to do so may result in applications being delayed or points reduced or even denied, such as page 2 of the application instructions right at the top under the general instructions. It lists that the applications need to be typed. Further on down, that paragraph 2, or 2 paragraphs later rather, still on page 2 there, it spells this out very clearly with a written example, and even gives, again, a written example with a specific citation for a criteria. And then right in the facility location requirements, very near this scale drawing requirement, is another mention that all attachments must be clearly labeled with the applicable ordinance, and this is 2 paragraphs above the scale drawing requirement on page 13. For this section, the appellant does not seem to argue that they, saw the requirement for this, but did not place it in that section, but rather that the document was there and in a different section. I seem to have lost my citation for where it was said to have been placed. But further, they're arguing that, not having this one thing shouldn't really result in a loss of half the points. And the problem there is that the scoring criteria, or the scoring metric itself, only allows for 3 levels, and it's a very deficient, a somewhat deficient, and then the complete or satisfactory. I believe that this area was properly scored as somewhat deficient in that during the initial application review, the section that should have contained the document with the scale drawing of the property illustrating the parking and handicapped accessible with a surveyor's signature and seal just was not found. For the sanitation section, the scoring criteria lists only 3 items. A facility sanitation plan needs to be there. Number 2, a plan for ensuring proper treatment and security of the waste. And 3, contracts with service providers for waste disposal and treatment. This commissioner could not locate any agreement or a letter of intent from a waste disposal provider that stated that they would, had an agreement or would have an agreement in place to take care of this in the event that the applicant was granted a license and could proceed. So again, with one of 3 items missing and only 2 tiers on this scoring metric, I have to agree with the deficient, since only those 2 tiers exist. I don't find the arguments arbitrary or capricious, and I must agree that I would score it similarly.
I would just like to back up Commissioner Maley's comments with, we have heard before from other applicants and appellants stating no contract under the facility sanitation. No contract is required to be submitted. But all I want to point out is right here in the criteria scoring form. It's on page 6, line 50 says contracts with service providers for waste disposal and treatment. All right, and I will yield to Commissioner Wilson, if you'd like to comment.
I would also like to read, before going into my discussion, the appellant's position. The applicant is seeking review of City Ordinance 2357B. It argues that the original examiner did not score correctly on overlooked presented material with respect to the following categories. Number 1 was under facility planning. Number 2 was under facility sanitation. And number 3 was under land use, neighborhood land use. That's the position that they're arguing. One of the things that I would like to add to what has already been said, when I look at Greenstone Natural Remedy on August the 20th, they were given a score of 120 out of 130. The hearing officer did review their case, and on November the 19th, the hearing officer made a recommendation to change the score from 120 to 125 out of 130. Some of the things that I observed are basically some of the same things that my colleagues have already observed, especially when I look on the city planning. There and again, the instructions for the applicant were clearly spelled out on pages 12 and 13 of 21 in the permit for the application's instruction. The instructions were clearly spelled out as to what was needed. Secondly, under the application process again, on page 14 of 31, the instructions were clearly spelled out. However, I did look into the material that was there, and when I reviewed tabs 19 and 20 that was in the package, neither of those appeared to be sealed diagrams or scale diagrams that was called out. Also, when I looked at tabs 19 and 20, they were not placed in the correct sections. It clearly spelled out that the information had to be placed in the correct section, or you ran the risk of being denied or deducted points. When I look under facility sanitations, as a result of the process that was in effect at the time, the application affirms, and I'm affirming, the 1 out of 2 points that was issued, based on the same thing that I just said about city plannings and the instructions that was spelled out in the package. Last but not least, on the land use and neighborhood, when the hearing officer did look at the package, he awarded an additional 5 points, which brought the total from 120 to 125. There and again, the same material that I reviewed, which is the same material that the hearing officer had access to. I have to agree with the assumptions and everything that was made based on the instructions that was given in the application process and also in the permit application that was to be turned in. When I also look at the instructions that was given under city planning and facility sanitations, the instructions were clearly spelled out again. I would like to move on to the resolution. Resolution on Greenstone Natural Remedies appeal to the Medical Marijuana Commission. Whereas in 2018, voters approved the City of Pontiac Medical Marijuana Facility Ordinance 2357B. And whereas Ordinance 2357B gives the city clerk the responsibility to score and rank applications for provisioning center using a 130-point scoring system and awarding permits to the 20 highest scoring applicants. And whereas the City of Pontiac adopted Ordinance 2363, an ordinance to include medical marijuana facility use in designated overlay districts, and whereas Ordinance 2363, Section 2.546, Medical Marijuana Provisioning Center, Section F, licensing states that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay districts, including Cesar Chavez, Walton Boulevard, and C2 Downtown Overlay District. And whereas Ordinance 2363, no more than 5 provisioning centers shall be established in the C1, C3, and C4 zone properties combined outside of the medical marijuana overlay district. And whereas the city clerk accepted provisioning center applications by overlay district and the non-overlay for a 21-day period, January the 6th through the 27th, 2020. And whereas the city clerk ranked the scoring provisioning center by district using a 130-point scoring system. And whereas the city clerk informed Greenstone Natural Remedies that their application for a provisioning center in the non-overlay had received a score of 120 of 130 and a ranking of 9 out of 48 on August the 20th, 2021. Whereas Greenstone Natural Remedies appealed the score and ranking to the city clerk since its application was denied because it was not ranked in the top 5 for the non-overlay. The city clerk appointed Graywell Law, PLLC, to serve as the hearing officer. The hearing officer conducted a hearing on October the 29th, 2021. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation. Based on the hearing officer's recommendation and other appeals in non-overlay, Greenstone Natural Remedy ranking changed from 9 to 6 and remained not ranked in the top 5. Therefore, Greenstone Natural Remedies application was denied. And whereas Ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission, and whereas Greenstone Natural Remedy submitted an appeal to the Medical Marijuana Commission on December the 29th, 2021, and whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Greenstone Natural Remedies appeal, and whereas the Medical Marijuana Commission reviewed Greenstone's natural remedy appeal and the city attorney's recommendation. Now, therefore, be it resolved, the Medical Marijuana Commission find no basis to overturn the city clerk's decision to deny Greenstone Remedies application for a provisioning center in the non-overlay. Motion is in order to act on the resolution.
Motion to take action.
I second the motion.
It's been moved and properly second for taking action on the resolution. Roll call.
Wilson,
Yes.
Maley,
Yes.
Pratt.
Yes.
Motion to take action on the resolution has been approved. Item number 5, A discussion on Quality Roots LLC appeal. Any discussion on Quality Roots LLC appeals?
So Quality Roots is the non-overlay application number 104, proposed location at 18 North Telegraph Road. And tonight they are appealing the facility planning subsection with a score of 4 out of 8. And the community impact physical improvement subsection score of 1 of 10. The facility planning, again, as laid out, is the deficiency noted, and the appeal was centered around the scale diagram and the fact that such a document could not be found within the appellant's application at the location it was supposed to be meeting the scale drawing specifications that's stated under Section 8.c.19, and needing to be prepared, signed, and sealed by a licensed professional surveyor. The document simply wasn't in the section that it needed to be, on this one, there was argument going on with a drawing being produced at the hearing officer, but was found to be unacceptable because, again, we're scoring the original application and ranking them based on their completeness. And without that information, it's just not possible to grant a perfect score in that section. So I have to agree with the scoring of 4 of 8. And that's all I have on this.
Point out in the physical improvement category, it was noted that there were attachments that were not labeled correctly and simply placed the scale diagram in the physical improvement section. So it wasn't clearly labeled, and the requirements were not met, as showing, for instance, Section 9F8 states the applicant must submit documentation showing proximity and proposed marijuana facilities to other structures, did not follow the instructions, and did not provide location, area, and proximity map labeled as the 9F8 subsection there. So they got 1 point for that. I agree with that. On the other hand, in the neighborhood land use, the appellant was originally awarded 10 points, but was reduced to 5 after a review, because a reviewer did overlook property labeled and submitted information. So the hearing officer, and I agree with that, recommends the city revise the scoring back up to 10 of 10. So that did increase their score there. And I'll turn over to Commissioner Wilson, if he has anything on that.
There and again, I basically noticed the same thing that my colleagues have noticed, especially on the physical improvement. No need to go into the conversation again, as he has stated that it was improperly labeled. And when you look at the process on page 18, see page 18 of 21, it clearly says failure to properly label attachments may result in being delayed or denied. So when I looked at the same material, I saw the same thing that my colleagues saw in items on the physical improvement. When I look on the land use for neighborhood, there and again, agreeing with what they did see, the hearing officer looked at that, and he made a recommendation to the city clerk to award an additional 5 points. At the start, on August the 20th, Quality Root did score 111 out of 130 points. After the appeal to the hearing office and the hearing officer's recommendation, to the city clerk. They were awarded an additional 5 points on the land use and neighborhood, which raised their score to 116 out of 130 points. So we basically had an opportunity to relook at the same packet that the hearing officer looked at, and I too come to the same conclusion that they have come to. With that, I would like to read the resolution for quality routes. Resolution on Quality Routes LLC appeal to the Medical Marijuana Commission. Whereas in 2018, voters approved the City of Pontiac Medical Marijuana Facility Ordinance 2357B. And whereas Ordinance 2357B gives the city clerk the responsibility to score and rank applications for provisioning centers using a 130-point scoring system and awarding permits to the 20 highest scoring applicants. And whereas the City of Pontiac adopted Ordinance 2363, an ordinance to include medical marijuana facilities use in designated overlay districts. And whereas Ordinance 2363, Section 2.546, Medical Marijuana Provisioning Center, Section F, licensing state that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay districts, including Cesar Chavez, Walton Boulevard, and C2 downtown overlay districts. And whereas Ordinance 2363, no more than 5 provisioning centers shall be established in the C1, C3, and C4 zone properties combined outside of the medical marijuana overlay district. And whereas the city clerk accepted provisioning centers application by overlay district and the non-overlay for a 21-day period of January the 6th through the 27th, 2020. And whereas the city clerk ranked and scored provisioning centers by district using a 130-point scoring system. And whereas the city clerk informed Quality Routes, LLC, that their application for a provisioning center in the non-overlay had received a score of 111 of 130 and a ranking of 17 of 48 on August the 20th, 2021. Whereas Quality Routes, LLC, appealed the score and ranking to the city clerk since its application was denied because it was not ranked in the top 5 for the non-overlay. The city clerk appointed Graywell Law, PLLC, to serve as the hearing officer. The hearing officer conducted a hearing on October the 29th, 2021. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation. Based on the hearing officer's recommendation and other appeals in the non-overlay, Quality Route LLC ranking changed from 17 to 12 and remained not ranked in the top 5. Therefore, Quality Route LLC application was denied. And whereas Ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission. And whereas Quality Routes LLC submitted an appeal to the Medical Marijuana Commission on December the 27th, 2021. And whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Quality Route LLC appeal. And whereas the Medical Marijuana Commission reviewed Quality Routes appeal and the city's attorney's recommendation. Now, therefore, be it resolved, the Medical Marijuana Commission find no basis to overturn the city's clerk decision to deny Quality Route LLC's application for a provision center in the non-overlay. Floor is in order for a motion to take action on the resolution.
Motion to take action.
I second the motion.
It's been moved and properly second. Take action on the resolution for Quality Route. Roll call.
Wilson,
Yes.
Manley,
Yes.
Pratt.
Yes.
It's been moved and properly second to accept the resolution for Quality Routes. Next item on the agenda, public comments. Anyone wishing to make a comment, you have 3 minutes and you're welcome to use the mic at the podium in the rear.
Thank you and good evening. My name is Frank DeLuca. I'm here representing Greenstone Natural Remedies, who received a score of 125 out of 130. As an initial point, you indicated during your reading of your decision that originally it was a score of 120 out of 130 that was revised by the hearing officer. The reason why it was revised by the hearing officer was because the original person that scored the application totally missed documentation that was provided, and the hearing officer reflected that by giving the additional 5 points to 125 points. There are 5 points that are in question here under 2 separate issues. The first is facility sanitation. It's the second night I've been here, and it's a recurring theme. The issue that the deduction of points on my client's application was for not having the actual contract from the waste provider. Greenstone submitted exactly what the ordinance requires, a detailed plan describing how the waste is going to be stored and how the unusable marijuana is going to be disposed. It's a 20-page plan. It has a waste provider that for waste management company, and no, a contract was not provided simply because that's an impossibility. You cannot enter into a contract with a waste disposal provider until a business actually commenced. Last night and tonight you referred to something called a letter of intent. Again, there's no requirement in your ordinance for a letter of intent. There's no mention of a letter of intent in your application. There's no mention of a letter of intent in your criteria. No such thing exists. Simply to deduct a point because you have one line on page 6 of a scoring criteria that says you should attach a waste contract is not grounds to deduct points. It's very arbitrary and capricious. The second section, as you indicated, really amounts to your contention that the document that was submitted was not a scaled diagram that was actually executed and signed, prepared and signed by a certified surveyor. That's completely inaccurate. Our HC19 document that was attached is a scaled diagram that was signed by our architect, but if you actually look at the face of that document, it states right on there that the information, the survey information for that document was provided by Chemtech and Associates, which actually produced a topographical survey, and that information was uploaded to our architect and incorporated into that scaled survey. So it's our contention that we did provide that document. It was properly marked, and it was in the package. And the fact that the surveyor didn't actually sign that particular document, that scaled document, that should not result in a deduction of 4 points. I would also basically submit that what I've heard tonight and last night is you've got 3 operative documents. You've got an ordinance.
You have 3 minutes.
Okay. Thank you. Oh, finally, I would also mention that this is not due process, gentlemen. Due process is you don't read the decision. You don't not give somebody an opportunity to argue their position. This is just a complete farce.
Good evening, Craig Aronoff on behalf of Quality Roots. I would echo the last statement as far as the due process and the ability to actually argue a case before a review hearing rather than just be read what was the outcome from the review without further discussion. As it relates to Quality Roots, similar to the other discussions regarding licensed, signed, and sealed survey, in our application, interestingly enough, the reviewer said that it wasn't signed and sealed, and that's the reason that it was denied. Again, we would argue it wasn't required to be signed and sealed. The document that was provided clearly was from an engineering and survey firm. It was clear on the document and the face of the document itself. As we get to the hearing now, what we're said is it wasn't in the right section. But when we read the way the rule is written, it actually says that if the failure to properly label attachments may result in the application being delayed or denied. May. It wasn't required to be. If you see it in the document, you get to still use it. It was in the application. You all acknowledge it was there. And so for purposes of denying it, it means you're taking the position that you must have denied it, rather than you could actually look at it and say, well, I see it's here. It was provided. It actually has the zoning locations and the distance requirements as required by the application. So the information was actually in the application. It was simply mislabeled, and you're saying it must have been labeled correctly or it can't be used. That's actually not what your ordinance or the application instructions actually say. So as the reviewers and as the appeal review hearing should have done is use your own judgment that it's here, this is a complete application. And so to that end, I'm disappointed to hear that you didn't take that position. We're not satisfied with the outcome. We'll pursue our remedies ahead, but I just wanted to point out that when you read an ordinance and say may, it doesn't require you to act. It gives you discretion. And I would have loved to have seen you use that discretion tonight. Thank you.
Anyone else? Motion for adjournment. A motion for adjournment is in order.
Motion to adjourn.
I second the motion.
It's been moved and properly second to adjourn this meeting. The time is 6:54. Oh, roll call, I'm sorry. Roll call for adjournment.
Maley,
Yes.
Parath,
Yes.
Wilson.
Yes. Time is 6:55.
Guys all right? Wish we weren't having to do this.